This story broke last week, and there's now an update to it. The backstory is that an Oklahoma court late last week decided that state law doesn't really criminalize forcible oral sex with a victim who's completely unconscious, and it stemmed from a case involving a 17-year-old boy accused of assaulting a 16-year-old girl after volunteering to give her a ride home. They had both been drinking. The girl was clearly very badly intoxicated. She had to be carried to the defendant's car. She was reportedly coming in and out of consciousness. She ended up at a hospital, blood alcohol level of 0.34. They did a sexual assault examination, and it turned out that the defendant's DNA was on both the leg and mouth of the 16-year-old girl. The boy said, oh, the girl consented to sex. The girl ultimately came out of her stupor. She has no recollection of it whatsoever. The boy was charged with forcible oral sodomy. And here's where the legal craziness starts. Follow this if you can, because it's so insane. The trial judge dismissed the case, and then an appeals court ruling affirmed the dismissal, saying you can't apply forcible oral sodomy laws to a victim that was incapacitated by alcohol, because the patchwork of laws that exist, Lewis says, that if there's intoxication that prevents consent, it only applies to vaginal and anal intercourse. And I apologize for the graphic language here. It's not written to apply to forcible oral drunk intercourse. This is, of course, another one of those examples where you have this patchwork of laws that is written in such a way that is both archaic and totally not related to the way that the world actually works. Oklahoma has a totally separate rape statute for those who are too intoxicated to consent. So forcible oral sodomy is covered by the non-intoxicated sexual assault laws. But if you are intoxicated, oral sex happens to not be covered right now. Of course, they've called an emergency session now. Lawmakers want to fix this loophole. This was not some retrograde Oklahoma thing that everybody's cheering and defending. There's a recognition here that this is not a good thing. Another one of these examples, Lewis, where the laws are just really leaving gaping holes.
It's everywhere. It's not just this type of these types of acts that we're talking about here.
Yeah.
Look at technology. Look at I don't know, Dave, it's all over the place. We have a lot of catching up to do, and it's incredible that this was overlooked for so long.
Well, remember that New York child porn thing where someone was exonerated from child porn charges because they did not actually download the images in the sense of right-clicking them in your browser and hitting save to your desktop or your hard drive. They just viewed them, which of course does create a cache in your internet browser. So you really are sort of downloading it for practical purposes. It's not really different. I guess you're not saving the files neatly in a folder
And
that
it
quickly
at least exists on your computer in your memory temporarily, right?
Right. And so that quickly had to be changed by New York state lawmakers, and they did do that. Real microcosm of the problem in this Oklahoma case, yet another example.